CPL 260.10. Except as provided in 320.10, every trial of an indictment must be a jury trial. Now, I got this question wrong because it was a true or false, and it said, except as provided in CPL 320.10, every trial of an indictment or SCI must be a jury trial. And apparently, in the book, in 260.10, it does not say anything about an SCI. So, that's why I got that wrong. 270.35 sub 1. If a discharged juror was the foreperson, the court shall designate as the new foreperson the juror whose name was second drawn and called. A peremptory challenge is an objection to a prospective juror for which no reason need be assigned. Upon any peremptory challenge, court must exclude the person from the jury. CPL 270.15 1-A, which are true concerning the court issuing a protective order regarding disclosure of the business or residential address of any prospective or sworn juror. 1. Good cause must be shown. 2. Counsel for either party, people, or defense shall not be covered by the protective order. 3. A motion for a protective order may be made only by people, defendant, court's own motion, or the person affected. And right out of the book, it says, court may, for good cause shown, upon motion of either party or any affected person or sua sponte, issue a protective order for a stated period regulating disclosure of the business or residential address of any prospective or sworn juror to any person or persons other than to counsel for either party. Such good cause shall exist where the court determines that there is a likelihood of bribery, jury tampering, or of physical injury or harassment of the juror. So, they can't prevent it from being disclosed to counsel for either party. I think that's what it says. Okay. Such good cause shall exist where court determines that there is a likelihood, not substantial likelihood, just plain old likelihood. So, good cause shall exist where court determines that there is a likelihood of bribery, tampering, or injury or harassment to the juror. The court, after they swear the first round in, this is talking about, the court may thereupon direct that the persons excluded be replaced in the jury box by an equal number from the panel, or in its discretion direct that all the sworn jurors be removed from the jury box and that the jury box be occupied by such additional number of persons from the panel as the court directs. Sworn jurors who were removed from the jury box may be seated elsewhere in the courtroom, separate and apart from the unsworn members of the panel, or may be removed to the jury room or be allowed to leave. The process shall continue until 12 persons are selected and sworn as trial jurors. The juror whose name was first drawn and called must be designated by the court as the foreperson. If, before 12 jurors are sworn, a juror already sworn becomes able to serve because of reason of illness or other incapacity, the court must discharge him or her and the selection must be completed. A challenge for cause which is not made before he is sworn as a trial juror shall be deemed to have been waived, except that a challenge based upon a ground not known to the challenging party may be made at any time before a witness is sworn at the trial. If it's allowed, the juror is discharged, and the selection shall be completed in the manner except that if alternate jurors have been sworn, the alternate juror whose name was first drawn and called shall take the place of the discharged juror. Immediately after the last juror is sworn, so immediately after the last juror is sworn, the court may direct the selection of one or more, but not more than 6 additional jurors to be known as alternate jurors, except that in a prosecution under 125.27, the court may direct as many jurors as they want. Okay. In a prosecution for 125.27, where they're looking for a death penalty, which they can't anymore, but whatever. In discretion of the court may direct the jurors to say. If they return a guilty verdict, the alternate jurors are not discharged and shall remain available for service during any separate sentencing proceeding which may be conducted pursuant to 400.27. .20. Upon a new trial resulting from an order declaring a mistrial, the indictment is deemed to contain all the counts which contained at the time the previous trial was commenced, regardless of whether any count thereafter was dismissed by the court prior to the mistrial order. Okay. So, this is the motion for mistrial 280.10. At any time during the trial, the court must declare a mistrial and order the new trial under the following circumstances. Upon motion of defendant, error or legal defects or conduct inside or outside the courtroom, which is prejudicial to defendant and deprives him of fair trial. 2. Motion of people, where there occurs during the trial gross misconduct by defendant or someone acting on his behalf or by a juror, resulting in substantial and irreparable prejudice to the people's case. Again, for the people, they have to have substantial and irreparable prejudice where the misconduct occurred. Okay. And then upon motion of either party or sua sponte, when it is physically impossible, proceed with the trial in conformity with the law. So, like, all the court officers walk out and go on strike or something. All right, so again, for the defendant, it's just prejudicial, deprives him of a fair trial, error or legal defect. For the people, it's substantial and irreparable prejudice by a defendant or someone acting on his behalf or a juror. And then the one by all three is physically impossible to proceed in conformity with the law. 300.30, here's some definitions. Court's charge. 1. Submission of account of an indictment means submission of the offense charged therein or of a lesser included offense, or submission in the alternative of both the offense charged and a lesser included offense or offenses. When the court submits account, and that's in quotation marks, it must at the least submit the offense charge. And why won't you focus? Oh, there we go. When the court submits account, it must at the least submit the offense charged therein if it is supported by legally sufficient trial evidence, or if it is not, the greatest lesser included offense which is supported by legally sufficient trial evidence.